Good morning or good afternoon to all the participants. Thank you for participating in this webinar titled Lessons from Recent Legislative Changes and Corruption Cases in Latin America. I am fortunate to share this space with my esteemed colleagues Pedro Serrano Espelta from Marval O'Farrell Mairal in Argentina, Thiago Gabor Pinheiro from Machos Filo in Brazil, and my name is Juan Francisco Gonzalez from PBP in Ecuador. Thank you all for coming. Today we will be discussing three major corruption cases in Latin America as a means to convey relevant lessons for corporations that do business in the region. This will be a conversation amongst colleagues, so we all will share our points of view and insights when necessary. And we invite all participants to send their questions through the system, and in the hopes that we will all be able to answer those questions and involve you in the conversation. To start, my colleague Thiago will talk to us about the famous Lava Jato case. Go ahead, Thiago. Thank you.
Hello. Good morning, everyone. It's a real pleasure to be joining Juan and Pedro for this discussion and to have you all take time of your busy schedules to join us. So thank you very much. I think the Lava Jato case is sort of the older brother in the room. It has been going on for a little bit longer than the other cases that we are going to be discussing today, and can be, really put at the origin of the recent drive for anti-corruption enforcement and legislative changes that has been going on in Latin America in recent times. So it's considered, or widely considered, to be the largest corruption investigation ever, including the Money Politi case in Italy and even the enforcement actions that are brought by US authorities. And it's really a case of huge numbers, be it of individuals, of agreements, of settlements, and of the amounts involved. All of this, of course, as most of you may remember, began in early 2014 when Brazilian authorities were investigating a black market money dealer called Alberto Youssef for different crimes. He had already settled and entered into a plea bargain agreement with authorities for a previous case many years ago, and in which he had committed not to engage in additional criminal action. He violated that agreement, of course, and was conducting money laundering operations for several companies and individuals when authorities were investigating him in late 2013. At some point, authorities identified that he had given a Land Rover as a gift to a former Petrobras official called Paulo Roberto Costa. And that called the attention of authorities because it was really uncommon for someone who mostly operated in the south states of Brazil to be involved with someone who was based in Rio and had an important, in fact, a very important role in Petrobras, which is Brazil state-owned oil company, and at various times over the past decades, Brazil's largest company. So authorities started pulling that thread in early 2014 and then launched what came to be known as Lava Jato. 5 years later, Lava Jato has recently launched its 60th phase. So you can just by the number of phases and the number of operations that have been conducted so far, you can see the incredible scale of this investigation. And it has, of course, generated a number of offsprings. So what began in the oil and gas sector and focused mostly on construction contracts expanded both within Petrobras. One of the recent phases of car wash of Lava Jato, for instance, focused on trading agreements, so the agreements through which Petrobras sells its commodities. So it expanded beyond construction to reach other kinds of services that were rendered to Petrobras. It also expanded outside Petrobras. It expanded to other sectors in the economy that are now in the focus of authorities. I've mentioned some of them in the slide. Healthcare, for instance, mostly with contracts for the acquisition of equipment and medical devices in the state of Rio. That was where the sector of the economy first began to be the focus of investigations. It expanded to marketing, advertising for state-owned companies. It extended to loans by Brazil's development bank, National Development Bank, BNDES. It extended to toll roads concessions, which is now, I think, the hottest phase in the investigation, mostly focused on the state of Paraná. But just last week, we had a different investigation beginning in other states, such as Goiás and Espírito Santo. And of course, Lava Jato has generated offsprings also in other public prosecutors' office located in other states, such as Rio, Distrito Federal, and São Paulo. So it really now, Lava Jato has a lot of developments in different sectors, in different prosecutors' office, and it's really hard to predict when all of this will be, or be reaching its end. We in Brazil believe it will take many years before all of these investigations unfold, and we are likely to see new phases and new sectors as the investigations proceed. Just to give you an idea, to wrap up and then move on to the notebooks case in Argentina, I've put it on the screen some numbers of car wash. The prosecutors that are responsible for the investigation have recently announced new plea bargain agreements. So we're talking about almost 190 different plea bargain agreements, 11 leniency agreements. There are others that are still subject to confirmation. So this number should increase. Far more than 400 individuals were charged and or convicted, depending on the phase of the operation. And this includes high-profile businessmen. This includes high-profile politicians such as former President Luiz Inácio Lula da Silva. And prosecutors are now going after over 40 billion reais in recovery and fines, which is, of course, almost $10 billion. So this shows you a little bit of the scale of the case, and all of these numbers are likely to increase in the next few years, which highlights the riskier part of doing business in Brazil, which we will be discussing later in this webinar.
Thiago, I have a question for you. What is your perspective on Brazilian authorities cooperating with authorities in other countries? Because as you know very well, the case has expanded from the Brazilian border. So I'm really interested in understanding how you perceive that cooperation from a Brazilian standpoint.
Now that's a great question, and this is one of the distincting factors of Lava Jato. Cooperation between international prosecutor agencies in Brazil have always been very formal and very time consuming. So Brazil has treaties with certain countries in Latin America and in other parts of the world, which were called mutual legal assistance treaties, that define how authorities are to cooperate and share information among themselves based on court decisions and other mechanisms that are fairly well regulated. Despite of that, those mechanisms were not used frequently until very recently, when authorities decided to, and by authorities I mean especially federal prosecutors, decided that they needed a better way to cooperate. And so federal prosecutors have begun to not ignore, but to create other mechanisms of more informal cooperation. So I think two characteristics are very important. One is that prosecutors increased their contacts with their counterparts abroad. So for instance, in 2017, Brazilian prosecutors led a region-wide discussion with other prosecutors agencies in all of Latin America, and including in that, and also in Portugal, and they've reached an agreement to cooperate. So they've established their own mechanisms of cooperation that don't necessarily require MLATs. This is one of the aspects. The second aspect is that informal cooperation has now begun to be a really distinctive feature, whereby prosecutors will exchange information in conference calls. They will have WhatsApp groups where they exchange information. When they travel abroad, they will take documents with them to show to their counterparts in other countries. And then, if there's an interest, then they will begin the MLAT procedure. But the prosecutors will have already known the important piece of information, and then the MLAT procedure is used just to formalize that avenue of cooperation. So you're perfectly right in the sense that international cooperation between countries in Latin America and between Brazil and especially Switzerland and the US is now a very real trend, and it evolves both through legally formalized mechanisms that are different from MLATs and that are in addition to MLATs, and it also evolves informally by constant contacts and really close relationships between prosecutors in different countries.
Great.
Let me just, Thiago, this is Pedro. Let me just comment on that, if you allow me, Juan Francisco.
Of course.
We know that in Argentina, these cooperation agreements are limited, since Argentina, according to the old regime, to the old laws, cannot grant immunity, for instance, to people who have collaborated with the case, like in Brazil. So one of the largest obstacles, for instance, in getting the information related to the bribes allegedly paid by Odebrecht in Argentina, which amounts to around $35 million. I mean, one of the largest obstacles is that information was obtained mainly through the collaboration of individuals in the case. And if that information is handed over to Argentina, then Argentine prosecutors would have the obligation to prosecute those individuals. Since that's not possible, according to the guarantees that Brazil gave to the collaborating individuals, that information cannot be shared yet. But as Thiago rightly mentioned, there are a lot of informal channels that have been developed between Argentina and Brazil. And I know because they've mentioned they have barbecues over weekends, sometimes, as Thiago mentioned, also WhatsApp groups. So prosecutors and judges in Argentina are very likely to have that information already, even though they don't have the evidence to try the case. But with that info, they might be able to know where to look. So we can see, or we can foresee new developments, even though the formal hard evidence has not reached Argentine courts yet.
Great. Thank you for that insight. It's important to take note that cooperation is coming in the form of barbecues, and in any other form, it will be interesting how this matter of cooperation develops.
Yeah.
The next case from a chronological order is the Petro Ecuador case. This case involves multiple general managers of Petro Ecuador, which is the Ecuadorian government oil production entity. The crimes involved in this corruption scheme are bribery, money laundering, unlawful enrichment, and the case may lead up to a case against the former Ecuadorian Vice President Jorge Glass, who is currently in prison for the Odebrecht case, not for this case as of yet. The bribes paid in this case were channeled through government contractors through offshore entities and agency agreements with other offshore entities that resulted in the delivery of bribes to the same individuals in Petro Ecuador. What is interesting about this case is that it pretty much started in the United States without the cooperation of Ecuadorian authorities. Two mid-level Petro Ecuador individuals arrived to the United States and were detained for money laundering issues. And from that point on, they have been cooperating with the US authorities, and now they are in prison in the United States. As you may guess, the United States may try to obtain cooperation from these individuals, and this could eventually lead to other indictments in the United States. From an Ecuadorian point of view, the case has involved 24 investigations. 109 individuals have been investigated at this point. And also at this point, 40 indicted individuals are now in prison. The other thing that is important to note is that this case has not received enough cooperation from government entities such as the public prosecutor, who deliberately delayed the delivery of information from Brazil in regard to the Odebrecht case. And it has also lacked the cooperation from the former Comptroller General of the country, who had, in accordance to Ecuadorian law, had to deliver a probable cause for criminal indictment, and he didn't deliver that because he was part of the corrupt scheme. At this point in time, the former Comptroller General fled the country and is now in the United States. This case, before going onward, may lead up, as I said, to the indictment of former Vice President Jorge Glass and other high-level individuals. It is yet to be seen. It is important to note that very recently, a week ago, we had elected a new public prosecutor, and she might be a little more active in prosecuting and going onwards with this case. That is what I can tell you briefly about the Petro Ecuador case. And please, Pedro, if you can go on with the notebooks case in Argentina.
Thank you, Juan Francisco. I will do so. So the first lesson we have is that all these cases are somehow tied together, and we start to see that happening as evidence unfolds. Like we mentioned before, the Odebrecht case is not only Brazil, it's the whole region, and we will see that the notebook case in Argentina is tied to different cases in different countries, the Lava Jato case, for instance. So it's not easy to provide an overview of the notebook case in just 5 minutes, but I promise to do my best. Since we have many participants from different countries, I will make a bit of history and will tell you why, in my opinion, this case has forever changed the Argentine landscape in relation with corruption and the way the judicial system tries corruption cases in Argentina. So going to the history part, as many of you know, this case started because of a driver, Oscar Centeno, who used to drive Mr. Barata, a public official, around for many years. Allegedly, Mr. Barata was collecting bags with money from different sources, most cases businessmen. And Mr. Centeno was very tidy, very organized, and he would write down amounts of money, because from one stop to the other, he would open the bags and count the money, for instance. Amount of money, dates, addresses, even names. And nowadays, he's also mentioning conversations that Mr. Barata had with other public officials, including Mr. Kirchner. So these notebooks, 8 of them, ended up in the hands of Mr. Diego Cabot, a journalist of the La Nación newspaper. And they started to run their own investigation. And when they realized that these notes were for real, instead of advertising the news in the newspaper, they handed over to a prosecutor and a judge. They run their own kind of jurisdictional analysis and consider that the best judge was Mr. Bonadillo, because he had tried a different case with Mr. Centeno. And then they work together, journalism and the judicial system, or the court and the prosecutor, and they work together with this evidence. And in August of last year, they issued order to detain many people, to seize computers, records, and all of that. And only after that happened, the newspaper La Nación advertised or published what they had gotten back in January. So this is a very good example of how what the difference makes when journalism and the judicial system collaborate instead of running to advertise this before anybody else. Having said this, we can see that the notebook case, as a summary, has involved already more than 100 companies and businessmen. You have, we've seen already more than 6 individuals indicted, including top current and former public officials. We have more than 30 defendants who have already entered into cooperating agreements with the court. So this is just a brief summary of what's going on. And I would say that the notebook case would not be possible without some laws that were passed by the Macri administration. Mainly, I would say law 27304, which is the repentant law, the law that allows judges and prosecutors to enter into agreements with defendants. So this has given the judicial system a lot of information and has speed up cases in a way that we've never seen before. Traditionally in Argentina, a corruption case would last, an important one, no less than 10 years, 20 or even more. And we see that this case, which started in August, will move to oral trial very soon. The ramifications of cases like this one is not only the corruption part, it's what comes along with that. For the government, particularly, the problem is that when the names of individuals and the name of the companies show up in the newspaper, shows up in the indictments, then financing tends to disappear from these companies and from the projects that the government is intending to foster. So lack of financing is lack of public works. That's not good news for the government, even though it's a result of the efforts of the government to fight corruption. Another ramification we can see from this case, and we may see in the future actually, is that due to the admissions of the defendants, it's pretty obvious that most of the companies, or many companies, were acting together, rigging public bids and working together in order to determine which company would win. So we can expect some antitrust actions in the future in order to go after the companies that coordinatingly allow others to win some public works. We can see also, we can foresee some class actions as well. And like I would say the last part, I'm going back to the notebook case itself, it's the allegations that the monies paid to Mr. Barata or other public officials for the sort were actually money for political campaigns, which is a very important distinction, because it's not the same saying, okay, I paid this amount of money for a political campaign than to say, I paid this amount of money in order to secure this contract. If that type would be made, then all that public works could be challenged in court, and there are many legal ramifications that can be associated with that situation. I think it's 5 minutes already, or a bit more. So, Juan Francisco, back to you.
Thank you, Pedro. Going onwards with the more practical section of this webinar, I will kindly ask Thiago to provide the first lesson that these cases bring up to the table.
Great. So just before we move in, one thing that I think it's important to highlight on the issue of cooperation is that the willingness of prosecutors to cooperate really depend on the level of trust that they build between different prosecutorial agencies. So in Brazil, for instance, has developed a very close relationship with the US authorities, to the point where US authorities now agree sometimes to take a more passive role in matters that involve Brazilian prosecutors, because they have developed trust in how Brazilian prosecutors conduct their cases. And this is a striking feature, and it's not the same level of trust between different prosecutorial agencies. So the willingness of prosecutors to cooperate may be different depending on the level of trust that exists between enforcement authorities. I have just a couple of weeks ago, I was discussing with in a call with a former DOJ official and asking him that exact question, and he said there are countries with which we would be very, very careful in cooperating, because we don't necessarily trust that they will use the information properly, or that they will conduct the case properly. So we may withhold information from certain prosecutorial agencies that we would give to other prosecutors. So it really depends on the level of trust that exists with the specific agency. So going to the lessons that companies should take from all of this that is going on in Latin America, I think the first one that I would like to highlight is managing relationships. Is really knowing your relationships with your service providers and with your business partners. There is an estimate by the OCDE that at least 75% of cases that have settled on corruption charges over the past many years really originated from bribes that were paid through third parties or intermediaries. So companies that either have good controls in place that would prevent them from paying bribes directly, but not as good as to prevent them from paying bribes from third parties. So those contracts, services contracts, are really the key in terms of how employees will attempt, or normally attempt, to circumvent internal controls and get the bribes out of the door without the company being aware. So that is a reality that companies need to be aware of, and this is particularly the case in Brazil. If you look at the cases in Lava Jato, most of the cases involved a third party, either as a way to funnel out money or as a way to create a level of protection, so to speak, between the company, or a buffer between the company and the public official receiving the funds. The black market money dealers, or doleiros, are the big responsibles for that. And they usually operate a network of thousands, literally thousands of companies, which sole purpose is to issue fake invoices that would allow the money to move. And this has been the target of Brazilian authorities, and particularly of tax authorities. So this is a reality. It's especially worrisome because, at least in Brazil, there is a strict liability standard. So if your service provider decides of his own that he will pay a bribe because he needs to perform a contract that he has with you, and he's caught, that is your responsibility under Brazilian law. regardless of whether you authorized that payment, regardless of whether you instructed that payment, or even if you knew that that payment was going to happen. It doesn't matter under our law. All it takes is that a bribe has been paid when someone was acting on your behalf or on your interest, so that you can be held liable. And even in other jurisdictions, I think Pedro and Juan can comment on specific points of local law. Those laws require a heightened duty of care. So even if there is no strict liability, the standards for holding companies liable are decreasing continuously, if not for legislative changes, for enforcement and case law. So nowadays, it's much easier for companies to be held liable than it was in the past. So this is another issue that should be really taken into account. So how to do that? How companies should behave in that scenario of heightened risk and of strict liability. It's the importance of having adequate procedures in place to filter, hire, and to monitor the actions of third parties. And what does that mean? When we talk about adequate procedures, you really have to have a very detailed policy that will allow you to understand who it is that you're hiring for any specific project, that you will have background checks, that you will be able to understand what that service is, that you have a competitive process that really makes sure that you're paying the adequate amount for an adequate service, and that you really communicate to your service provider what are the criteria that he needs to abide by in conducting business with you. So that's a very strict and careful selection process to make sure that you're hiring the right people. And once that is once you make a decision, once you know who you're hiring, that you have the adequate contractual protections in place to allow you to monitor the actions of that third party. And when we're talking about contractual protections, we really have three that are key issues that you need to make sure that they exist in your contracts in Brazil. First is you have to have clear declarations and obligations from your service provider. So it's the famous reps and warranties, right? You have to have declarations in there. And the most important of them is that the third party is aware of your policies and your rules and your compliance mechanisms, and is committing to abide by those guidelines. It's committing to comply with every single aspect of your compliance program, and that has to be a very clear declaration on his behalf and a very clear commitment in the contract that he agrees to abide by that. So you either include detailed instructions, or you attach your code of conduct. And if you have a specific code of conduct for suppliers, which many companies in Brazil are now adopting, that is even better, because then it's something directed at your service provider and something that he commits to in writing. So that's the first element. The second element is, of course, how and what is going to trigger your rights under the contract, either to be indemnified or to be able to get out of the contract. It's very common in Brazil, and I know that there's the same problem in other countries in Latin America where compliance is a new topic, that people will put in very general clauses of compliance and say, if the service provider is accused of wrongdoing, I can terminate the contract and not pay the full amount. Well, that is a very vague way of describing what the trigger for your rights will be. And we've had cases in Brazil recently where third-party service providers, even if they had committed wrongdoing, were able to challenge the termination in court because the contract was vague, the contract didn't mention specific triggers, and so you end up taking a decision for compliance practices, which is very justifiable, but you face difficulties because your contract is not clear in what it is that you can use to terminate contracts. So one thing that we've been advising a lot of clients in is try to make your contracts more specific. Be clear on what it is that will allow you to get out of the contract or will allow you to receive indemnification for. That's the second thing. And the third thing, which is important, is to make sure that you have the right monitoring capacity, right? So you have audit rights that clearly describe what are the documents that you can request, who is going to pay for that audit, and what sort of information you're allowed and which frequency you can require that information to be provided. So those are the three contractual protections that I would recommend. And of course, and this goes especially for people who occupy positions in committees or in boards, beware of red flags. I've highlighted here the 5 main red flags that we see happening in practice and that should really call for additional review. So if you're in a selection and hiring process and you come across those factors, you really need to stop and ask additional questions. First, unclear services. There's someone being hired to do something and you cannot for the life realize what it is that the person is doing. Very vague contracts, providing general advice on all matters related to the company's activities. This is not a properly described contract. So you have to really be specific and to make sure that you understand what services are being provided. Lack of expertise. We've seen many cases where there are very expensive consulting services being rendered by IT companies, or very expensive IT services being provided by law firms. And these are all concrete cases that we have seen in the past. So if it seems that the person being hired has no expertise to do that sort of work, you have to ask additional questions. Overpriced without technical support, right? If you hire a very reputable law firm like the firms of my colleagues here, it is expected that they will be somewhat more expensive than if you hire any law firm that you find in the street. So, but there's technical support, there's expertise supporting that. There's reputation. So try to understand if you're paying a price that really is adequate for the technical expertise and the reputation of the party you're hiring. If it's a very expensive service, but you never heard about that person, there's something wrong about it. Fourth, payment abroad. It's very common, services being rendered in Brazil or in Ecuador or in Argentina, and then a third party will say, well, can you make the payment in my BVI bank account? That is also a very common red flag. And finally, background checks. Background checks sometimes will give you very useful information, but that information is only useful if you act on it. So if you try to understand what it is that the background check says and how to address or mitigate those risks. So those are the 5 main red flags that we see in practice and have to be brought together with the other 2 points to make sure you really you understand and manage your relationships well with third parties. The second general lesson that I would like to highlight is how to deal with stakeholders. So it used to be the case that in the past, only governments will be interested in those violations, right? Nowadays, that all has changed. If a company is all of a sudden involved in a compliance matter or in an investigation, a lot of people will come knocking and asking questions. And you really have to make sure that all of those requests for information that are coming from different sources are properly met. Otherwise, you may face contract terminations, you may face denials of services, you may face difficulties in selling your product if you're unable to provide adequate response and adequate action when problem happens or when something does occur. There are different stakeholders and their demands are different. I've listed here the 5 more common stakeholders that really ask questions when something happens. The first is shareholders, right? If you're a publicly traded company, this is especially relevant. What sort of information you're required to provide to your shareholders and investors? How do you make sure that the proper information is being vetted and being communicated? If there's something that you're not communicating to your shareholders, Make sure that there are legitimate reasons for that to happen, and there are a lot of situations where it is in the best interest of the company that some information be kept private, at least for initial review, not to create an undue noise in the market and then violate the rights of shareholders. So really understand what sort of information you're required to share, and if there is information that you cannot share, that you have properly understood it and that you have good grounds not to share that information. Second important stakeholder, contractual counterparties. Almost all contracts that you will have with sophisticated counterparties, which tend to be your most important counterparties, either suppliers or customers, will have some form of compliance clause in there. So you really need to understand what sort of rights your counterparties have if you violated an anti-corruption law, what kind of actions you need to take. Do you need to notify them? Do you need to provide any additional, do you need to act proactively in communicating that to their stakeholders? So normally what we would recommend is that you really have a book or a summary of all anti-corruption clauses that you have with your key counterparties, so that if something happens, you can quickly react and quickly provide the necessary information. The third one is our banks and creditors. Banks especially are very active, and they have very sophisticated monitoring mechanisms, and they will always reach out and ask questions. If something happens, they will want to know if their money is being properly used. So those banks, especially foreign banks, are very, very sophisticated. They will require you to prove that you're taking action. They will normally require that you conduct an investigation and that you provide and keep them informed of what's going on. We've seen banks in Brazil sometimes hold on credits, and it's been more rare, but sometimes they call on their loans when something like that happens. So you really have to be sure that you're proactive and that you're managing their expectations well. Auditors, very common. Auditors are being increasingly careful because prosecutors and authorities are targeting auditors sometimes. So they are very careful in trying to understand what happened and if that has any impact on the company's financial statements. So they've been conducting what we call shadow investigations, in which they will really look over the shoulders of whoever is responsible for investigating and understanding what's going on, and they will require increasingly growing demands from companies and action. And of course, you cannot forget your employees. These are the people who, when a crisis hits, they suffer, right? They are in their, having lunch with their families on Sunday, and then there's always an uncle or an aunt who come and say, so your company paid a bribe. Are you going to jail? Are you sure you need to be working there? So employees sometimes suffer a lot when this happens. So you need to be able to communicate with your employees. You need to be able to let them know what's going on, and you need to be able to provide them with information they can share when people ask, so that you're not having advocates for you outside of in their daily lives, as opposed to people who will sometimes not be able to explain or not know what to say. So these are the two main lessons that I wanted to highlight from our experience with the Lava Jato case in Brazil, and that companies should be mindful of when conducting business in the region.
Thank you, Thiago. The next lesson I believe we can obtain from these cases is the importance of the role of the compliance function as a means to prevent and detect corruption. In all the cases we have talked about, we find companies that acted unethically or illegally in ways that could have been avoided if someone with enough ethical values, with enough knowledge and powers, would have stopped such acts and that downward spiral. That individual in the team is called to identify acts of corruption or unethical behavior is the compliance officer or the leader of the compliance function. Normally, multinational companies have a compliance officer. In the region, due to budgetary or size restrictions, companies tend to appoint not a specific individual to the compliance function, but to appoint someone within the company to cover that function. That individual has to manage multiple responsibilities, make sure that the company is compliant with regulations, not only legal regulations in the country, but also if you're talking about a multinational entity or an entity with shareholders from other countries, you have to observe the law of other jurisdictions and also the internal policies of the company. That individual must perform periodic risk assessments as key to prevent corruption. And in addition to being a risk assessor, that individual must become an opportunity seeker for the company. When risks appear, definitely the compliance leader must find the ways to lead the business to act safely and go ahead with business as usual. That individual must evaluate business activities. Of course, that individual must perform training as a means to prevent corruption and as a means to tell employees and company personnel how they should act when a compliance incident appears. Of course, that individual must manage concerns and reports, internal investigation, which Pedro will talk about later. And of course, the compliance function must report to the board. Most companies now understand the importance of having the compliance function, having a seat at the board, or having a direct communication with the board member and the CEO. The compliance function has to, the individual who will lead compliance within the company has to have a specific set of qualifications. He or she must be, of course, an ethical individual. When something unethical or illegal is going on, that individual must act and must report to the board and must take action. Otherwise, those illegal activities will perpetuate within the company, and that will become a bigger problem. The compliance leader must also be a risk expert. And again, I emphasize that when risks appear, the compliance leader must be creative enough in understanding how to overcome those risks and in specific circumstances determine that a certain transaction or certain process must not go onwards. The compliance leader must be a trusted advisor to the board and must have the capacity to be someone who stops trouble. And most importantly, the compliance leader must be a trusted business partner. It happens sometimes that the compliance leader is seen within the company as the no person, as the person who will stop business from going onwards. And that is a perception that needs to be changed in the region, in the region and in other parts of the world, because the compliance leader is not there to stop business, but to make sure that business can go onwards without unnecessary difficulties. And of course, the compliance leader must be an effective communicator in regard to training, in advising the board, employees, and of course, a communicator of the company's ethical procedures and policies with third-party providers who, as we have seen, are a huge focus of corruption or potential corruption. The fourth lesson I believe we can obtain from the three cases we have talked about is that compliance programs are effective means to prevent and detect bribery. It is important to note that according to statistics, we see that almost 20% of employees have observed corrupt acts within their companies, which is a huge number. We also know that prevention of that compliance programs are useful to prevent heavy legal penalties and reputational harm. We can all agree that a company that appears in the notebooks or in any corruption case will be exposed to a high level of reputational harm. In regard to heavy legal penalties, I can tell you that in Ecuador, under the criminal code, if a company is found guilty of bribery, the necessary penalty for that company will be dissolution and liquidation, which is a very strong penalty that is stronger than in most jurisdictions, where dissolution and liquidation will only be the pettiest penalty in the most terrible circumstances. But here, no. A bribe, regardless of the amount or the gravity of the situation, will result in the dissolution and liquidation of the company. That's why we believe a compliance program might be an effective way to prevent corruption and not expose the company to such a situation. Compliance programs are important in detecting corruption because we believe that what cannot be detected cannot be solved. If the company closes its eyes to what's going on within the entity or in regard to specific individuals or third-party providers, the company is exposing itself to circumstances that are not desirable. And finally, I will just mention briefly that compliance programs are good for business, and my colleague Pedro will talk to us about that. The key elements to take into consideration when you are talking about compliance programs, there are multiple standards and checklists that have been issued by the OECD, and other sources. I will only mention a few ones that I believe are key in the region. So from the top, we have talked about this. If management is not willing to demonstrate a willingness to ethically and legally, so either, I believe that the three cases we have talked about, the most important issue that happened in all those cases is that the companies, government contractors lack tone from the top. So this is a huge issue. The next thing is risk assessment. Compliance practitioners, we all know that the risk assessment within the company is the cornerstone of a compliance program. Your program will not work if we don't do the homework of understanding what are the risks of your company. The third element is localization. When we are talking about multinational companies doing business in Latin America, as we say in some jurisdictions, that compliance program must be tropicalized because the risks and the human element in the region is different from other parts of the world, and that is something that we have to take into consideration. Of course, training is absolutely necessary as part of an effective compliance program. The training must be engaging, practical, and entertaining, and of course, that training must be frequent and in Portuguese or Spanish, depending on the country. Incident reporting and management. If incidents are not properly managed, what will happen, the risk that the company will be exposed to, is that that individual who wanted to present a report or report an incident will go elsewhere to report that incident, and that will create a bigger liability to the company. And finally, review and measurement of the programs. Now we have systems and software to automate the determination of if the compliance program is working or not. Bigger companies have this capability, but measuring how your program is working is necessary. For instance, you can measure how many people are within 100 members of your company are reporting incidents, how many business partners have compliance programs or compliance procedures or manuals. Those type of measurements might be effective in determining if your program is. Now I turn the microphone to my colleague Pedro.
Thank you, Juan Francisco. Before going to the good business sense, which is very important, doing all of this is good for business at the end of the day. Let me just make a few comments in relation with what you mentioned and what Thiago mentioned, and some kind of takeaways. Have in mind that in Latin America, all of this is cross-border, so let me mention Latin America, not only Argentina, Ecuador, or Brazil. The judicial system or courts are not that independent. Many times you have countries where the judicial system is more independent than others. This could change when presidential elections are close. That is happening in Argentina right now, for instance. And many times you have you need to make a more micro analysis on trying to determine which judge or which court is more independent than others, because judges are political people as well in many cases. So it's not only making an analysis in relation with the evidence, but also in relation with what that prosecutor or that judge could do at certain time. Maybe this judge will act in this way now, maybe it will act differently in a couple of years when the elections are coming. So that's something to have in mind if you are a compliance officer. Another common in relation with what Thiago mentioned, contractual clauses that you can include in order to deal with corruption, okay, you have a partner that is involved in a corruption scandal. What can you do with that? Let me give you an example. Many of the companies included in the Notebook case were part of joint ventures with other companies. And what happened in many cases is that the government stopped paying them for services that they were provided. So like maybe a public work that was being underway, being constructed, and then payment stopped. Basically, the message was, we are not going to make payments to companies that are investigated or part of a corruption case. That, of course, it's a lot of strain on the business. And many times what happens is that the other partners need to buy out this company from that business just in order to secure future payments. So going to the contractual clauses, maybe it's important to include that in the agreements to deal with that. Be very sure that you determine what is a corruption case, or what stages of the case are allowed in order to deal with this. Maybe a way to deal with this is drafting put and call options that could be exercised at certain price under some circumstances. Some circumstances could be if you have a company that is trading its stock or maybe bonds in the stock market. I mean, a drop in the stock price could be kind of a triggering event for exercising the call or the put. And finally, before I mention briefly the good business sense for this is personal responsibility. What we see in many jurisdictions is that when a case starts, prosecutors and judges, they include everybody in the company. For sure, directors, even alternate directors that never acted at the board level, they are included there, they are indicted. Then you have managers and all the employees that had some kind of participation, like maybe they sign, authorize the payment of an invoice that is under scrutiny. All of them are included. And as I mentioned before, these cases may last for years and years and years. If you are in there, you're in trouble already, even though you might be acquitted at the end of the day. So as a personal level, be sure that you know what to do. Maybe you have an indemnity agreement, D&O insurance covering your acts, whatever. Have that in mind, please. And in order to be out of the responsibility, be sure that you have a paper trail that is somehow instrumenting or evidencing all the actions, the good actions you've done in order to prevent a corruption case or corrupt act, or maybe that you sent an email to a superior informing this, and keep that in a safe place in case you need to use it, because you might need to use it in maybe 10 years. So in order to wrap up and go into the good business sense, let me mention that You have three groups of cost in a corruption case. You have direct cost, level 1, direct cost, level 2, and indirect cost. Direct cost level 1 is basically the fines that regulators are going to assess on the company. Let's say the Siemens case, $1.6 billion overall, okay? Then you have the direct cost, level 2, which is professional fees, for instance. Forensics, accountants, lawyers, investigators, all of this usually amounts to 3 or 4 times the amount of the fines from the regulators. So you start adding up cost on this. Let me give an example. Walmart is spending more than $1.3 billion just in this direct cost, basically fees in relation with the corruption case they are facing now from the Mexico scandal. And then at the end of the day, you have the indirect cost, which is a level 3, which is basically something that is very difficult to measure, like reputational damage, like the change in the rating of agencies on the credit of a company, the turnover of the employees of a company. That's a big cost. You need to train many more employees in order to keep the workforce. You're going to have more supervision from regulators. That's going to delay business. You're going to lose clients, and relationship with third parties are going to be more difficult. So that's even more costly than the cost I just mentioned. I think we are just a few minutes over time. So what do you say, Juan Francisco? We call it a day, or we keep going on?
I have, maybe we can close with a few questions we have, and I ask both of you to provide your short answers to this. We received the following question is, what is your advice when the subject of the investigation is the CEO or a member of the board?
Okay, that's a very good one. I'm pretty sure that Thiago has a lot of expertise on that. Let me just mention that first advice would be, of course, that person could not participate in any part of investigation. That's to start with, which many times is a problem in order to bypass top-level management in order to deal with this with allegations. Secondly, it's important in these cases when you have top management compromised, maybe setting up independent investigators and people who are independent from the company who will deal with this and will issue recommendations to the company. What do you say, Thiago?
Yes, I think it depends a lot on what sort of governance structure there is at the company level. If it's a very sophisticated, publicly traded company, the company most likely has some independent board members. The company probably has an audit committee, and that has also independent members. And this is, in most cases, enough to ensure that the investigation will be conducted independently, even if it involves members of the board or the CEO of the company. So in that situation, I think it's much less complicated. When it begins to get a little bit trickier is when companies don't have that sort of governance structure, in which case setting up an independent committee could be a solution, or using the existing governance structures to make sure that that person is either recused from the board or has no access to the investigation. And this usually is easier when the company already has an independent compliance function that answers to the board. And I think the worst case scenario here, if it's a family-owned company and perhaps the CEO or the board member is also a shareholder of the company and a significant shareholder at that. So I think in that situation, it really is important for the compliance function to drive down the point that it is better for the company that that individual is recused from any decisions with regard to the courts. And I think that some of the stakeholders that I mentioned are allies in that situation, because if you have your banks and creditors asking for an independent review, if you have your auditors asking for an independent review, if you have significant stakeholders asking for an independent review, it's easier for you to convince the CEO or the board member who's under investigation that it is really better for the company as a whole that he recuses himself or allows the investigation to move forward. That is not always the case. I've seen cases in Brazil where compliance officers really resigned and decided to leave the company because they simply could not convince people to take on the the investigation with the level of independence that it requires. But usually, money is a pretty good way of convincing. Even in that situation, people, you can use the interests of the company, and in the end, if the company is hurt, the shareholder is hurt. So you really have to show the individual that the entire company will suffer unless the investigation is able to proceed with some level of independence to be able to provide the adequate comfort to the stakeholders.
Mm-hmm. Thank you, Pedro and Thiago. Unfortunately, we have used all our time, so we must close the webinar. There are a few questions remaining. We will take the time to answer those questions directly. And we thank you all for participating, and let's hope we have the chance to talk to you guys again and to have this many participants. Thank you, everybody, and have a good afternoon or a good morning. Thank you very much. Bye-bye.
Thank you all.
Thank you.
Bye-bye.
Bye.
Bye.